If everybody could stand, we'll say the Pledge of Allegiance, please.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Robert Turner.
Getting ready to send that police out.
Yeah. We're going to open the meeting. And could I have a second to open the meeting?
Second.
All right. And this meeting is for Day Mills Management Corporation. Petition to change, you guys are going to be changing to 55 and older. And do we have someone here that's going to speak? Yes, sir.
Well, thanks for holding the hearing tonight. I'm Tom. Yes.
I have to read the announcement first.
Oh, okay.
Sorry.
Sorry about that, I cut you short.
That's all right. The rules. Town of Templeton, public hearing notice. All persons being interested in zoning board of appeals acting under the town of Templeton are hereby invited to a public hearing to be held on Wednesday, April 19, 2017, 6:30 p.m. at the Narragansett Regional High School, 464 Baldwinville Road, Baldwinville, Massachusetts, 01436, KIVA Room. To consider the request by Marcus, Errico, Emmer, and counsel for the Board of Trustees for the Mill Townhouses Condominium Trust. The trust seeks to remove the condition of the comprehensive permit issued by the Town of Templeton Zoning Board of Appeals, requiring that 62 units in the condominium be subject to a 55 or older age restriction. The basis for the trust application is that the comprehensive permit age restriction is unlawful. All interested parties who wish to be heard shall be heard. All relevant documents for review are located at the offices of the Planning Board and Town Clerk, 160 Patriots Road, East Templeton. For further information, call the Planning Board office at 978-894-2767. John Fletcher, Chairman, Templeton Zoning Board of Appeals.
All right.
Thank you, and thank you, gentlemen, for holding the hearing tonight. I'm Tom Ellsworth. I'm the attorney from Marcus, Errico, Emmer Brooks, here on behalf of the Condominium Board of Trustees. And I'm the attorney who wrote the application that was submitted that triggered the meeting for tonight. And I guess, you know, I know you've read the papers, and obviously, very simply, what we're here for is, on behalf of the Condominium Board, is to ask that the age restriction be removed from the comprehensive permit that was issued by this board. But before I really get into why that is, I just want to point out that, you know, we're very sympathetic and aware that there are unit owners who purchased their units at this condominium thinking that there was an age restriction. And I know some of those people are here tonight, and I know they're probably going to want to talk to you, and we also want to hear from them. And we feel terrible about that. It's a terrible thing to buy a condominium unit and to be told you're going to be in at least a partially an age-restricted community, and then a number of years later to be told by some lawyer who represents the condominium board that it's illegal and that the board wants to remove it. And we're sympathetic to them and take no great pleasure in having to do this. And they have every right to be upset. They really do. But the point is that that was a problem that was created by the developer of the condominium. And that developer is long gone. And this condominium board, who I represent, the trustees, they were the ones who got stuck with this problem. And they have an obligation to the condominium to do something about it. And so, in spite of the fact that they would rather not have to hire me to be here tonight, and rather not have to ask that this age restriction be removed, they're compelled to do so for some very practical reasons and necessary reasons that I'll talk about. And I don't have a lot to say tonight, but I do feel that a little bit of background is helpful. It was in 2004 that this comprehensive permit was granted by the ZBA. The developer of the condominium was a company called Day Mill Management Corporation, and its principal was a gentleman named Stephen Kozakowski. And under the comprehensive permit, that developer was authorized to build 150 units, and that would be the Day Mill condominium. Out of those 150 units, in the in the comprehensive permit, there were several conditions. And condition number 5 in the permit was an age restriction that 62 of the 150 units were to be age restricted, meaning 55 and older. So that was part of the comprehensive permit that this board, or I presume your predecessors on this board, they approved that. 62 out of 150. Well, one problem occurred, and as sometimes it does in these larger developments, the developer never finished the project. So out of 150 units that the developer was supposed to build, he only built 115. And there are only 115 units today. And you probably have seen, it's a pretty little community, it's just down the road here, right? Only 36 of those units were age restricted out of the 115. And that's by virtue of what the developer did. When he created them, the developer, I shouldn't say he, it's really his company, this company, Day Mill Management Corporation. It's Day Mill Management that only created 55 units that had age restrictions. I mean, did I say 55? Only
36.
Only 36 of the units have age restrictions. And so when the developer stopped building, and there were issues that we don't need to get into, but the developer stopped, Mr. Kozakowski stopped building and left the project. That's the situation that my clients were left with. And the problem is, even if the additional 35 units that have never been built were built tomorrow, and even if all of them had the age restriction, it still would be illegal. And the reason is because there is a federal law that governs this age restriction business. And under that law, it's called the Housing for Older Persons Act. And it's part of the Fair Housing Act. And what the Fair Housing Act says is you can't discriminate against people in housing based on their family circumstances, and that includes you can't discriminate against people, for example, if they have children. And so ultimately Congress recognized that that was a problem and that we ought to be able to at least have some restrictions for age, and they created this exception under the Fair Housing Act, this thing called HOPA, which I mentioned, that is the Housing for Older Persons Act, HOPA. And what they said was, you can have an age-restrictive condominium or housing complex, you can do that, but there's a very important condition. It only is going to be lawful if 80% of those units are subject and restricted to the age restriction. Has to be 80%. Now, once they're restricted, you only need one person in each unit that is 55 and older, but it has to be 80%. And if it's not 80%, and the law is really clear on this, if it is not 80%, the age restriction is against the law and it's against federal law. And anyone who tries to enforce the restriction, including my clients, the trustees, could be sued under federal law. And so what happened here was, so now, even if so going back to the original comprehensive permit, for reasons that I can't tell you because I wasn't part of this then, nobody picked up on it. Even if the permit would have been complied with and 62 units would have been built with the age restriction, it's still not 80%. So it just never was a lawful condition, and I'm sure it was a perfectly honest mistake. Nobody was trying to pull the wool over anyone's eyes. It's just what happened.
Can I stop you for a minute?
Yeah.
Do you have any experience at all in the 40B project?
I do.
You do?
Yeah.
Because when we did this project, The town lawyers we had at the time had us get a lawyer that had 40B project background.
Sure.
That's what this was all written on.
I know
So I'm
that.
taking offense that you keep saying we did something wrong, or the developer did something wrong.
Yeah.
It was a 40B project, and with the stipulations for a 40B was to do what we just did.
Yeah. I really
And
am
unless
sorry.
you got something in writing to say that, then what you're saying to me means nothing.
Well,
Anybody can walk in here like yourself and say what you want. If you don't have anything in writing, then you can just save it for me, you know? I've heard enough already.
well, I'm sorry that I offended you. I don't mean to. And I'm sorry if I get your name wrong. Is it Mr. Devan?
Davin.
Davin, Mr. Davin. Please don't take my words as trying to insinuate that people did things wrong. And it clearly was something that just snuck under the radar screen. And what I have in writing, sir, what I have in writing is the federal law. And it just was a mistake. It was obviously an honest mistake. I don't think anybody intended anything to do anything wrong. It just happened. And sometimes in 40B, in my experience, mistakes do happen. This isn't the only time that something has gone wrong with a 40B project. And so nobody is, and so in spite of the fact that there was attorneys involved and all of that, this was just a mistake. And I don't know, when you say if I don't have anything in writing, who would I have it from? What I have is a law from Congress of the United States that I've cited in my papers, and that I would hope that your town council has researched, because that law states that there has to be 80%. So even though it was under a comprehensive permit, and even though you had lawyers involved, that doesn't make it legal if it violates a federal law. And no one should take offense at that. I'm really sorry about that, because I'm really trying very hard to impress upon you how I understand that nobody did anything here that was bad. It was just a mistake, and mistakes happen, Mr. Devan. They just do, and this was a mistake. And I'm not sure what kind of writing you would want from me, other than, as a lawyer, it's my duty to tell you what the law is, and what I do have in writing is a citation to the federal statute that says that this provision, this restriction is unlawful. And so that's, I don't have a letter from the governor, because I can't do that. That's not how it works. You know, when a citizen, and in this case my clients are citizens too, find that there's been something happened that was a mistake under the law, we have a duty to bring it forward to you. You're the permitting authority, and there's a permit that was granted that had a mistake in it, and it needs to be corrected. That's our position, and it's nothing more than that.
But you don't have any paperwork at all?
What?
I mean, from the government, for the state itself,
No, there wouldn't be any paperwork
that's stating that it has to be 80%?
Well, no, because it's an issue of federal law. So I don't really know quite what to say to you, other than the writing is in the law itself. The law says to be legal, there has to be at least 80% of the units, and it says units have to be under this age restriction. That's the writing. And you as a board, you are certainly encouraged to, but it's your choice to consult with your town council to see what your town council thinks.
Yeah, for sure.
Yeah, and your town council will read the law and give you legal advice. I'm obviously not here to give you legal advice. I'm here on behalf of my clients, but that's how the process works. And so you then consult with your attorney and find out what your legal advice is, and if it agrees with mine, it does, and if it doesn't, it doesn't. But that's how the process works. You're the people I have to go to get this fixed, not some other state agency.
I have a question.
Yes, sir.
Just because the developer didn't follow through with 150 units, why would that have effect? Because they were supposed to put 150 units in there.
Right.
So why should we have to? Because it's not us, they're the ones that messed up, the developer.
Yeah.
It still wouldn't equal the 80%.
No.
Yeah, I mean, that's an excellent point. But as Mr. Smart just mentioned,
Yeah.
even had he finished all 150,
Right.
there wasn't enough age-restricted
Right.
units in this permit to matter. It would
Right.
still be unlawful. So the fact that he didn't...
I can't, you're making me angry saying it's unlawful. I mean, we spent a lot of time going through this
We
thing.
spent
and
probably 3-4
We didn't
months
have
on
just
this
a lawyer come in. He specialized in 40B projects. And a lot of the stipulations in 40B projects superseded any other law, is what we were told and led to believe. And until that changes for me, you're upsetting me, you are.
But Mr. Devan, you're upsetting me. I'm telling you what the law is, and you just disagree with me.
Absolutely I do.
What am I supposed to tell you? What I'm saying is, I'm not a judge, and if we disagree about this, ultimately a judge will decide it, but I'm telling you my position as an attorney, and I'm telling you honestly. And you can be mad all you want. I'm not doing it to upset you. Your position seems to be, we spent a lot of time on this, and therefore no mistake could be made, and unless you, Mr. Ellsworth, bring in something from someone telling me I'm wrong, I'm not going to listen to you? That's not right.
That's it, that's what I feel, I'm sorry.
Okay, and you're entitled to take that position, but I'm entitled in a public forum to express my professional opinion, which is soundly based on the plain words of the federal statute, that there was a mistake made. And like I said, mistakes happen. I don't, it's unfortunate that you feel so offended by this. No offense is intended, okay? And so I'll qualify my comments by saying this. When I say that the condition is unlawful, all right, understand that that is my professional opinion, okay? That's my professional opinion. And if that still offends you, I really am sorry. It's not intended to.
I think the bottom line is, we're gonna get our town attorney up here and go over this.
Yeah.
Or 40B.
I'd just like to tell you, I am from town council's office, so that, I'd be happy to try to answer any questions you have or to address this. Mr. Ellsworth is finished with his presentation.
Are you agreeing with him?
No, wait till he gets, he said he's gonna come and speak. Let him have his say and then
All right.
we go.
The reason why this became, I'll close with this. The reason why this became so important to my clients was because of something very unfortunate that happened. This wasn't just something they decided to do, and as I said, they would rather not even be here. But what happened was, they have been denied financing from a lender to complete the construction that started, but they can't finish it with this restriction. The lender has identified that this, and it's not just one lender, by the way, they've gone to several, who all have come to the same conclusion that this age restriction, their conclusion, okay, that the age restriction is unlawful and therefore they won't give them complete funding. And the reason why it's so important to them is they can't get the complete funding unless the restriction is removed, is because this project has had some problems that they inherited and that need to be addressed. And the only way that those can be addressed is with some very substantial construction projects. They need new roofs and they need new siding. And there's been some mold. There's been some mold. And it's been widespread. And so in order to get that funding and to get the lenders to agree to give it to them, the lenders have to be shown that the restriction, the age restriction is gone. And unless that happens, these critical repairs to the condominium aren't going to, it's hundreds of thousands of dollars, and it's the kind of money that can't be raised easily or quickly from the unit owners. They need loans, and that's typical with large condominiums, is they get construction loans. That's how the issue came to light, and that's why it's so important to my clients who are in charge of managing this condominium. And as long as this restriction is in place, the lenders, independent of me, I haven't talked to them, and their title reviews have revealed this problem. So that's all I have to say, and that's why we're here. Very sorry about offending you, because I really did not want to do that, but I feel it was important to state our position.
How long has your client had day mills? How long have they bought it?
How long has it?
They just bought day mills,
The new owners.
the new owners.
Well, I'm not sure what you mean by the new owners, but my understanding is, are you talking about when did the condominium owners take over the board?
Yeah.
I believe it was about 6 years ago, is that right? Yeah. What year was it?
You needed to know the settings were there, the roofs were there, then the mower.
Stepped down as being a board member about 2008 or 2009.
Okay. So the unit owners have controlled the board since the late 2000s? 2000, or, you know, for about 10.
I'm asking to come.
What is it?
You keep saying, my client.
Yeah, that's what I want to get at.
And you're only representing your trustees. And we've got a vote, none of us.
I'd like to ask a couple of questions,
Yeah,
if
go
I
ahead.
could, as a board member. It's my understanding there's 3 trustees on this board?
That's right.
Are they here?
They are.
Okay. How long have all of you been on the board as trustees?
Well, it was a year and a half, and my
About 8 years.
Okay, so you've been on pretty much since the purchase?
1 to 6 months.
Before the purchase?
The board, there was the original developer, and there was a board then, and then I came on right around the time that the developer stepped off of the board and was working as a consultant.
So were you on prior to this change of the ownership?
No, I wasn't on the board when he was on.
Okay, so you were after too. Okay, thank you.
Any other questions?
You have a question of the lawyer?
Yeah, I have one.
You talk, one at a time, though. I'm sorry, Joe.
They gotta speak the name.
You gotta go through the chairman.
My name is Jeannie Letelier, and I live at 7 Millstone Circle. And what I would like to know, what right does board members have to go out and secure a loan without coming to each homeowner to see if this was okay? That is illegal. We own this entire property, and yet you've got 4 board members that are gonna make a decision. Three. That's absolutely wrong.
Do they hold meetings?
Yes,
How often?
monthly meetings.
Monthly meetings?
Yeah.
Have you been to any of these meetings, ma'am?
Just
We set the doors a lot.
Have you? Yeah.
I have been there.
Okay.
If,
It would normally be brought up at a meeting, I would think, and discussed at a meeting
It's been discussed.
with your board.
This project's been discussed for many meetings.
Okay.
No,
And
it's in turmoil.
And Mr. Smart, the other thing I can tell you is that when it comes to condominium management by the board, first of all, the law makes it very clear that the attorney represents the board and does not have an attorney-client relationship with the unit owner. So I just
Right,
want to make
right,
that clear.
right, yeah.
The second point is that under the condominium documents, when it comes to maintenance, and this is maintenance,
Mm-hmm.
that the board has the power to do exactly what it's doing. And so although that's really not before you, I think a woman's question deserved an answer. And that's what it is that the condominium docs allow a board to, and the condominium statute allows the board to do what it's doing.
So it's my understanding in some of the paperwork that the reason for these loans and the whole changing of the permit boils down to that they needed money to do repairs that they don't have. The repairs are on common areas,
That's
which
correct.
aren't the condominiums. The common areas are areas used, I don't know if you'd call it hallways that pair off to different apartments. I haven't seen exactly the
No,
setup.
they're all individual, there's no hallway.
Well, that's an excellent question, and let me explain. In a condominium, a unit owner owns basically the interior of the unit. It's usually from the interior plane of the studs going inside. And what is common area is the structure, structural components of the building, the exterior, the roof, the siding, those things that, particularly here, the roofs and the siding, those are all common areas. And under the Massachusetts Condominium Statute, Chapter 183A, and under the condominium documents, the master deed and the condominium declaration that this condominium has, those common areas, including the siding, including the roofs, those are all under the specific management of the board. And so they are, for example, if somebody, if something fell off the roof, let's say a shingle fell off the roof and hit somebody in the head and they sued, they're not allowed to sue any unit owners, including the unit owner who lives in that unit that's underneath the shingle. They have to sue the board. If there's a problem with the shingles or the siding, no unit owner individually is allowed to make any kind of a claim. It's purely and specifically authorized to the board, and that also is true for maintaining it. It's all within the province of the board. Some boards, you know, and I don't know the history of this one, but how do I put it? If the board doesn't act when there's an issue facing health and safety, and mold is one of those, right? If they don't act, they can get sued. They can get sued. So they are obligated, they owe a fiduciary duty to the unit owner, well, to the trust as a whole. They owe a fiduciary duty to take care of that condominium. And that's what they're trying to do.
So if you had hypothetical, which I think it's an actual reality, if you've got a roof up here and a roof down here and ice builds up, slides down, falls down, crushes the roof, who pays the bill for that?
Well,
do you charge the owner that's inside?
No.
Because you don't own the roof?
No. That doesn't have anything to do with it. No, you don't. If the insurance company would pay for it, and the insurance is purchased by the board for those common areas. Now, in most cases, individual unit owners would have insurance to cover the interior, but that would come under the master policy that the board pays for through the association dues. That's who that would be paid for. As a lawyer, it's hard for me to tell you that my clients would be responsible, but in effect, you know, they would be responsible if there was negligence, and that's where they have to be careful. That's where they have to keep things maintained in good order. They're obligated to do that. And that's part of the duties of being a board member, which I guarantee you, especially in a case like this, is no wonderful thing to be in this position for them. They, as I've said a couple of times, they take no great pleasure in having to hire me to be here.
Hey, one other question. On the common areas, like I know they're putting new roofs on. Now, the owners, they're responsible for putting the new roofs on, or is that through the cooperation of the?
That's through the trustees. They're the ones who get the loans. They're the ones who hire the general contractor, and it's their responsibility.
Who pays for it?
The unit owner, the association generally.
In other words, the owners actually pay for this.
Oh, yes, of course.
Yeah, of course.
Yes.
That's for the condo fee.
Yes, that's right. A condo fees, but in case of projects like this, to pay for the loans, usually that there is a special assessment.
Okay.
Yes, but of course, no, it's all paid for ultimately by all the unit owners. And that's why I understand, like, some of the unit owners aren't happy with me because they think I represent them, because ultimately they're paying my bill.
Yeah.
They are. There's no doubt about it. But the law makes it very clear that legally I do not have a relationship with them as their lawyer, and it has to be that way because of the reasons we've talked about tonight. Not always the most pleasant for me either, because these are good people. You know, and they didn't deserve what they got from this developer, but the board didn't create the problem. They were stuck with it. They were stuck with it.
Joe?
Hi,
Yes,
my
ma'am.
name is Mary Chipman, and I have a condo unit at Day Mill. I have here a petition that I would like to submit to you of unit owners who do not want to lose the 55 and over designation. Also, I'd like to say that some of us, at least 7 of us, went to the board prior to this, them getting this construction company, and and we were turned down. We asked if we, as unit owners, which we felt lawfully, we should be able to vote on this. There's only 3 of them, there's 115 units.
I agree with
We
you.
felt it should be. But unfortunately, they asked me, who was your attorney? Well, it was supposed to be the association attorney, which was used against us to find loopholes to say that this work was necessary because it was, had to be, they used all kinds of semantics to justify what they wanted to do.
If you read your agreement under section 6, removal, trustees accept members from the first Board of Trustees, is why I asked if they were originals or not, may be removed for cause by an affirmative vote of a majority of the unit owners. No trustee shall continue to serve on the board if, during his term of office, he shall cease to be a resident of the owner. Unit.
Well, Mr. Smart, thank you for reading that, because the condominium documents, you're absolutely right. They have provisions if the unit owners are dissatisfied with what's going on with the board. And the woman who spoke and any other unit owner is more than welcome to run for the board and become a board member. They can do that, and if they have the votes, they can.
Okay, has your group or your petition ever gone to the point of trying to remove any of the people you're not happy with as trustees?
Not as of yet, but that could happen. I've got something else to say.
Well, just like in government in our town, we don't like who's in office, we muster up and vote them out.
It's not so much not liking them, we don't like what they've done to us. Not allowing.
Whether or not, I stated that wrong, like you just said, I didn't mean them, you not liking them or them not liking you, just as the lawyer doesn't technically try to make him mad, but he is. The situation is one that if you don't like what the Board of Trustees are doing, you remove them.
Have a vote.
Now,
Now, whether or not, if you remove 2 of them, your situation's gonna change with the mold, the roofs, the loan, it may not. And the biggest reason we're here tonight, and pretty much the only reason, is to listen to the attorneys tell us what their sides are, what the law is, what mistakes were made, and we just gotta sift through it and make a decision. That's what
Mr.
it
Smart,
boils
as you
down
can imagine, it's, and I'll say it again, I'm very sympathetic to what the unit owners are saying, and I'm sincere about that. It's a terrible thing that has happened. It is easy to armchair quarterback these situations, and what you find is that the people who are on the board often come under attack, and yet there is often an unwillingness of others to serve. And so, but that opportunity is available to them if they follow what's in the condominium documents. It doesn't, of course, change. None of that really obviously is before the board tonight. There's really only one issue that's before you. All of that is background, but you've got a board that has made the decisions it's made, and one of those decisions is to submit this application to remove the age restriction, and it certainly doesn't change the merits of those arguments.
There's a gentleman over here that's got his hand up.
Yes, sir.
Gerard Weiss, 70. What does this have to do with the 40B loans? That's what I'm interested in. How does that affect us? Because I believe that they kind of left that out. All of us, some of us here get
We have nothing to
40B
do with
loans,
the
and
loan.
we'd like to know if it would affect us as far as our condo fee is concerned.
We don't, excuse me, sorry to interrupt you, but we don't have anything to do with the loan. We gave, a 40B was just for the building themselves, and then Day Mills took care of everything after that. So that the money has nothing to do with the board up here. Yes.
We have had the 55 and older since the place was there.
Absolutely.
Why all of a sudden is it an issue to get rid of it? What's the problem?
Well, when we did it, we wrote it in so it would be 55 and younger, too. I mean, the low income.
We don't have the problem. That sounds like your association and the lawyers here have an issue.
Well, the lender.
Because the lender does, the bank does, to get the loan to do the project that they need to have done. There's someone over here, too.
Well, I saw that lady up there first.
Sally Waite, I'm the president of the board, 5 Millstone Lane. The reason this came up in the first place was because someone tried to get a mortgage, and the realtor dug this up and started the whole thing. And because of that, the person couldn't get a mortgage, and the banks have followed suit since then. And they're using this as the reason to not give people mortgages or loans.
Yes, because as you all, I'm sure know, when mortgage companies consider giving a loan, they do a title examination. And that's what happened here. And that's what, so the board didn't discover this, they were on their own. It was brought to their attention by a mortgage lender who did a title examination and came to what I believe is the correct but unfortunate conclusion that the age restriction violates federal law.
That's what I was going to say. And I'm Jackie Johnson, and I was at 9 Baldwinville Circle, and I'm new to Dana, not even a year. And we had an issue getting our mortgage because of the loan, what was actually in the deed of 55 over. So I'm probably a minority in this room, so I apologize, but I support eliminating the 55 over. And not because we didn't meet the qualifications, because we are at that age limit, but it really is an issue with getting loans. If anyone wants to sell their condo in the future, you will have an issue. We also have mold in our attic, and that isn't a big concern. I didn't even want to move there because of it. And we were reassured that that was going to be fixed. Now we're hearing all of this, and it's like, well, I wish I didn't buy because I thought it was going to be fixed.
When a person wants to buy a condominium unit, they apply for a mortgage loan, and the mortgage lender, as a matter of course, and they all do it, it's part of their procedure, they send a questionnaire to the board, and they ask a series of questions. And the board can't pretend that the issue isn't there. They have to tell the truth, and they have to at least point out that this restriction is there, and they have to point out what they've been told. I mean, they can't just hide it. And so they have an obligation to tell the truth. And so that hurts the marketability of these units. And the removal of the age restriction, although unpopular with the people who live in age-restricted units, will improve the marketability of their units substantially, and will for the entire community.
Yes, ma'am.
My name is Linda Galbraith. I live at Mill Drive in the complex, and I just want to add a little bit to what's been being said, because I think you're getting a lot of jumbled in my feeling, and this is just my opinion.
We're used to it.
Oh, good.
We get in at every meeting. We're listening, believe me. We all.
Yeah, I mean, it has been brought up, if we're not happy with the board, why didn't we get rid of them before this all started? Okay, you have to back up a little bit. It was found out that some units had mold. At that point, every unit was supposed to be checked to see who had mold, who didn't have mold. From my understanding, the outcome of that was that less than 50% of the people in Daymill have mold to some degree. That's when it was discussed that we need to fix that. I don't think there's anybody here, whether you want the loan, don't want the loan, you don't like the board, does not want that problem to be fixed with the people that have it.
Sure.
The problem is that when we did come down to having a large meeting about this project, we found out then it had already been decided, it was already signed. They had already signed and contracted to have every unit done, even though less than 50% have a problem. This is the main thing, and it just keeps mushrooming.
Well, and I appreciate the concern that's been expressed about those issues. And there's obviously, not unusual for large condominiums when problems arise, there is a dispute internally in this association. And they're going to have to work that out. But that's not something for you to work out, that's for them to work.
She needed to finish,
Oh,
though.
I'm sorry, I didn't mean to interrupt.
No, that's fine.
I didn't mean to interrupt.
We're here to just talk about things and get it out in the open. But, so the problem is, you're saying that this loan is for improvements. But they are only, if you want to call it an improvement, improving less than 50% of these units. But they are doing constructional works on the remaining units that don't have any mold. To me, maybe the construction is not terrific, but over 50 of us do not have mold. So why not get a loan that we can all handle, pay for? To me, that makes sense. Get rid of the mold, fix those people's places. But why go through all this for over 50% that don't have a problem? Granted, it would be nice to have the Cadillac. We can only afford the Ford. And I mean, that's how I look at it. You know, because like we stated, you can get a loan for whatever you want. We are paying for those roofs. We are paying for that siding. We are paying for those gutters, whether we need it or not. To me, this has been an adjustment because we should have been able to vote because we are paying for this. And we're fighting for our homes here. And nobody does not want the mold not fixed. He would like it to be fair. We don't want to give up everything so we can fix problems that really don't need to be addressed now. I mean, you can always keep checking units, see, okay, how is it in 2 years or whatever, and go along as we need to do things. But this is huge, a $2.2 million loan to encumber all of us because less than half of the people have a problem. Makes no real sense to me. And I'm just sorry. That's just how
No, it's fine. You don't have to be sorry.
Gentleman up there.
My name is Stephen Olson. I live at 13 Waterwheel Circle. I'm a former board member. And to explain what's going on, when the contractors built the buildings, they put no proper vents in the building at all, which means you have no circulation in the attic. The roof vents on the top of the roof are well, I don't know how to explain them. The worst ones you can buy, they're foam, and they're all crushed down. So you have no circulation in the attic. That's the reason why we're getting the mold in the attic. Because when they turned around and they put the vents in for the bathroom, they used a vent and they ran it down and they put it into the soffit, which is illegal. Okay? It has to go straight up. And that's another thing that this loan is paying for, so that we do not get mold back into these buildings. And I don't understand why people can't, I mean, I've seen pictures of the mold where everything is just black. And sure, everybody doesn't have mold, but it's not to say that you're not going to get it next week. And it's a lot cheaper to go through and do what we're doing, or do what they're doing now, to do them all at the same time. The roof shingles are almost gone. So what they're doing on this loan is they're taking up the first sheet of plywood, and they're putting proper vents in, and they're making sure that everything is vented, and they're putting in the best vent that they can on the top of the roof, so that we get some circulation in there, so that we can get it done. And then, what they're going to do, as these units get all completed, they're all going to be sprayed for mold, so that there's no more mold, and they can't come back. And I can't understand if you're a homeowner, and you have something that's wrong, why don't you want to get it fixed? I realize it's a lot of money. I don't want to pay it. But I also don't want to get sick in 2 years or 3 years because of the mold. And if you do it piecemeal, it's going to cost the board 3 times as much. And as far as the 55, yeah, when I bought my property, that was one of the reasons that I bought my property, because it was 55 and older.
That's right.
Okay, and that was one of the reasons. But when you start figuring things out, and if it's illegal, so if I go to sell my property, and the people that come in and buy it say, well, I can't buy it because I can't get a loan, that's putting me in jeopardy. So I feel now that it's almost a necessity to do away with that 55. It makes my property more valuable and easy to sell. But that's the reason why they're doing all of this, is because it was never done in the first place. And no one ever caught it, no one ever inspected it, or anything else. And it's just a shame that we as tenants or as owners have to put up with all this expense.
How long ago, you probably know the answer to this, how long ago was it that they found out they had a mold issue, the first inkling of it? Because that's when it all started.
Twice. That was probably the first time that we did it over. That was just when I was on the board. I've been off for 3 years, so it's probably about 4 years ago. And we have done some. We went in and mediated some of the mold. Even when I was on there, they mediated some of the mold. And it's just continuing because it doesn't have proper venting in the attic.
So 4 years ago, they knew they could have put new vents in the tops of the roof and did. Would have been a lot cheaper
Well, it wasn't that they
than
didn't.
what they're getting
It was
into.
that-
It was.
Places were already built.
I know, but you could put vents on the peak. That's the last thing that happens when you do a roof.
Yeah.
You cut and you put a vent all across the ridge.
Right.
That's not a lot of money to do that. I mean,
No, and
compared to your 2
You need
million.
the proper vents
Right.
down at the bottom so
Yeah.
that you get the air in.
The soffits in the top,
Right.
then something would be up there.
So it circulates.
I'm just curious,
No,
if
I mean-
it's something that just popped
And
up.
that's what they're trying to do now, is to get that done, so that we don't end up with a problem that the reason the roof shingles are gone is because of the heat that builds up in the attic has ruined the shingles.
Yep.
So it's all a compound of everything that has gone on, and if they can't get the loan, then what are we gonna do? We're not gonna have a roof, my house is gonna go down the tubes, I'm not gonna be able to sell it. So I just think that myself, that restriction needs to be taken off so that we can get on with our life. Thank you.
Thank you.
Thank you.
Anybody else? Nope. Oh, yes, ma'am.
Carol Porter, 32 Waterville Circle. I've been, I've owned my unit since February of 2005, the year after my husband passed away. I sold my farm because I couldn't maintain it, and I moved to Day Mill. I have so many friends here. I just don't want to leave, but I can't afford to stay if they're going to go through this. They've already got a $700,000 loan, they've got a $225,000 loan. Now they want to roll it all into more than 2.1 or 2.2 million. And I paid $229,000 for my unit. I cannot sell it for $129,000. And basically, if you go to without this over 55 designation, I won't be able to sell it at all, because that is a big thing, okay? My friends, I'm 80, she's 80, she's 81. Where are we going to go except into assisted living? I don't want to do that. And I
It's
love
very
the town.
nice. And
I love
assisted
the
living
town.
is very nice. I just moved my mother.
As a teenager, I used to come here to the Grange Hall, to the square dances. That's why I came here instead of going back to Lunenburg or Ashburnham. And I don't think we don't impact the town as elderly people. We pay our taxes. We don't have to have you come in and plow. The only thing I think you do give us is police and fire protection. But basically, we've raised our children, we've raised our grandchildren in most cases. and we don't need somebody moving in next door with 4 or 5 kids. It's sad to say, but this is why we chose over 55. And that's why we are against, and that's why I've been against paying for an attorney. We can't afford an attorney. If we got together, we could not raise the money to fight this in court.
Yes, ma'am.
I'd just like to clarify that $220 loan that we had before that was for the roads has been rolled over. It's part of the $710 now. It's not a separate one. And in addition, we have to fix this mold. Board of Health came to us and said we had to fix 1 unit because the unit owners called them. It cost us $27,000 for 1 building to fix just the mold in the attics. It had nothing to do with the roof, and now they're saying they want the roofs fixed. Everyone wants this mold issue to go away. They all want it fixed, but nobody has been able to come up with an alternative plan, and this seemed to be the cheapest way for us to do it, the most direct way. It'll all be done in a matter of months, and we'll have a new 25-year warranty. That says a lot for me. I'm in the 55 and over. I have the same problems as everybody else. I don't like it either, but the board's responsibility is to the buildings, and if we don't do it, if we can't fix the mold with this loan, then we're going to have to do an assessment, which is going to be thousands of dollars per unit, just to fix the attics. And it was going to be around $5,000 assessment just to fix the attics where it's going into the soffit. It has nothing to do with the vent through the roof. And fixing, we were told these shingles are supposed to be good for 30 years. Well, maybe they were, but fact is, when we had that big windstorm a couple weeks ago, we lost several shingles off of 4 roofs, and you can take them like this and rip them. And the man who was replacing them told me they were 10-year shingles, and we've been there, I think, 13 years or so.
Yeah, it seems odd to me you're replacing shingles already in a new complex. I consider it new under 25 years old.
Right. I think one of the problems is because of the improper ventilation, the heat builds up and it bakes the
Call it what it
shingles.
is, it's shoddy building.
Yeah, exactly.
Anybody here disagree with that?
No.
Okay. I don't know if there's an easy fix, but tonight what we're here for is to hear about the law. The law, and we love all of the input we're getting, and we're listening, but it's gonna boil down to what the attorneys have to tell us. We're gonna have to adjourn at some point and have a second part of a meeting eventually.
Well, we should hear from...
You want to hear from the town
We'll hear
attorney.
from everybody, yeah.
It's... Oh, there's a town attorney.
I know.
Okay. The children that move into the condominium is going to affect the town terribly, the school system. And also, like I say, I think it should be done. I don't think we should say, oh, maybe. Also, the tiles falling off the roofs and everything else, we have insurance. We have a big insurance policy that covers all kinds of things for people that are visiting and people that are living here. So I'm not concerned with that at all.
We hear from the town attorney?
He had his hand up there.
Oh, who did?
The attorney. He won't
Just gotta wait until the end.
Good evening. My name is Rich Huxham. I'm an attorney from Town Counsel's office. I'd like to answer any questions. Okay.
Is that all?
Are these mics set up, Carl?
I'll just try to speak louder. I'd like to answer any questions you might want to ask me, but I have a couple of points I'd like to make initially.
I'd like to hear that.
On this first point about the legality or illegality of the age restriction, I agree that there is a federal statute that says that 80% of the units are supposed to be age restricted. However, I think that's really just the beginning of the story. There's a fundamental principle of land use permitting law that a condition in a permit that is not appealed is valid and enforceable. So if it goes beyond, if you get a permit like this, or say a special permit, and goes beyond the appeal period, there's a statutory appeal period that limits the time you have to appeal. So normally, if you're an applicant and you get a permit and there's a condition in there that you don't like, you have to appeal it.
Yeah.
If you don't do it, you're stuck with that condition. So
What is that,
this
20 days? Is that what it is in here?
in zoning, it's 20 days. That's right, under the Zoning Act, Chapter 48, Section 17. This comprehensive permit has been, as you know, in effect since 2004. That's a long time, and it wasn't appealed, obviously. However, I don't think that you have to answer this question about the legality or illegality of the age restriction to make a decision, because in my opinion, the legality isn't really the issue. The issue is that the board, the condo board has come here and said, we need to get a loan, and we can't get the loan because of this condition. We're being told by lenders that we can't get the loan. So that's why the condo board is coming to you and saying, we need to get rid of that condition. And that's all that's before you. You know, there may be a lot of other issues surrounding the condominium, but that's all that is before the board. There are probably a lot of other issues and disputes that may be legitimate, but this board doesn't have the authority to answer those questions or adjudicate those disputes. Just this condition, not even the other parts of the comprehensive permit, just this condition. They've asked to modify it by removing this condition. That's all that's before the board. So it's really a judgment call for the board under the comprehensive permit law, Chapter 40B. One of the criteria for whether a condition is legal is whether it would render the project uneconomic. And that basically means that it would make it impossible to operate the project without economic loss. That's in Chapter 40B, Section 20. So that's one criteria by which the board could make a decision, but it's within your discretion. I'll be happy to try to answer any questions you may have.
I have one. I just find it hard to believe that, or maybe I should say, it sounds like the people they're getting a loan from and some of these real estate agents aren't familiar with the 40B project. Because this isn't the only one, they're in every town. And if that was the case, why wouldn't every town have the same issue, and they don't?
Yeah, that's a good question. You know, I think this could, it probably has a lot more to do with the lending standards for these financial institutions. I mean, they're just saying, what do we need to feel comfortable lending our money, and what the collateral for it needs to be. So it's more a matter of that, than really the legality of the condition.
I guess whoever their real estate agent is, or I guess even everybody in this room, where would they get the legality to correct the problems that they're having to get the loan?
I'm not sure I understand your question. I mean, getting rid of the condition.
How to set the lenders straight, I think. How do you get the...
There should be some, I guess there should be some wording somewhere that says, well, the way this day mill is set up, it is legal. And they should be able to get a loan without any issue because of it.
You know, again, I think it's a decision by these private institutions, lending institutions, whether they want to lend the money.
Well, so you're saying each lending institution has something different.
Well, I mean, I'm sure they come up with their own standards for whether they want to lend money.
It's the association is the main one that has the problem to begin to fix up the condos.
Well, they need to get
for everybody else to bother even keeping paying their mortgages.
Right.
You can't pay on an unsellable unit and you'd walk away from it.
Right.
You know, I don't know how else to say it.
Right. And I mean, I think in terms of the board trying to make its decision, it can consider what the facts it has before it as part of this public hearing that are relevant. And one of the facts is that the condo board is telling you, we need to do maintenance, and to do it, we need to get this loan, and we can't get the loan with this condition. We can't do the maintenance. That's sort of a factual allegation
Right.
that they are making.
Right.
To
What
the
I do
board.
is I walk it back a little more. That's why I asked if the trustees have been in, have they had the meetings, and we found out from some people that the vote was already taken and done
Yeah.
and applied for before a vote. So why couldn't they send a flyer to each owner, a ballot that states they are for it, they are against it? That makes our decision for us.
Yeah.
Because right now, as a board member, I don't, who's gonna be madder at me? You know? It's not, it's not an easy sell to go down that one-way street and say, this is the only thing you can look at.
Yeah, it's a very reasonable.
It's not a fair way, let's put it that way.
It's a very reasonable point, and a lot of the people who have spoken, have very legitimate concerns. But in my opinion, just based on what I've seen, a condo board has the authority to make decisions about maintenance of a condominium.
Yep.
And there doesn't seem to be any real question here that's within the board's jurisdiction about that. I mean, again, if unit owners were to bring an action in Superior Court and, make assertions about the authority of the board and that they're not acting properly and they haven't done things properly, that would be a different matter. The Superior Court would have authority to deal with that.
Yeah.
But here, the board's jurisdiction is very limited. It's just this one condition that's at issue.
We had a gentleman up back, he wants to speak, he's had his hand up a lot.
14 Millstone Circle. 2 points. Mr. Smart, you asked about a vote. 3 months ago at a board meeting, we asked these 3 people to allow us to vote on the project. Her comment was at the end of the meeting, we'll take it under advisement, which usually to me means no. Okay? The second thing is, 3 months ago, I refinanced our condo and I had no problems. Okay?
3 months ago. Was it with the same lender? Can I ask if it was with the same lender? Maybe the...
No, sir, different lender.
Okay.
Can you explain for me, I don't understand what 40B has to do with the 55 and over,
That's what the project is, where you live.
but isn't the 55, it's a separate section, isn't that?
That's how it got to be the elderly in that section. It was a stipulation in the 40B project. It had to be like
So as
that.
part of that process, the 55 and over was put in?
Yes.
Okay.
There was one gentleman up back first.
Before they turned around and actually signed everything, we had a meeting to explain what was going on. We had the contractors in. They had a very tight schedule to get things done so that we could get this done as soon as possible. And if I'm not mistaken, and I could very well be, I thought at the end of the meeting, Sally asked if everybody was in favor or not in favor or whatever. There wasn't any complaints at that meeting. At the end, when it was all done and it explained on what we were doing, nobody seemed to have a problem. So I took it that we had a vote they had a vote to go ahead and do it.
Yes, sir.
I thought the town council's comments were very helpful. I do have a response to a couple of points that I think may be also helpful. And that is on the part about that a condition in a permit is deemed valid unless it's appealed within the appeal period. I can't remember what it is, 21 days or whatever. That's true as it applies to the parties who are involved in the permit. For example, the developer in this case lost his right to appeal the comprehensive permit once the appeal period passed. Fair enough. That doesn't mean that that at that point the permit is effectively legal for all purposes, and that no one who has a party in interest in the future is barred from trying to change it. By way of example, let's say by some error or just by some prejudice that there was a place that said we'll allow a comprehensive permit, and the restriction is that we're not going to allow anyone in that condominium who belongs to a religious group. Christians can't come in. And the developer doesn't appeal it. That doesn't make it lawful. Somebody who's affected by that would have an opportunity to try to change the permit, also to go to court and sue over it. So it doesn't make it lawful merely by the fact that it wasn't appealed. It means that, for example, in this case, the developer was stuck with those conditions. But that doesn't stop anyone from challenging it now. And it certainly doesn't stop someone who would be affected by this age restriction, which we think is illegal, from suing. They can do that because the federal law, in my professional opinion, says that this restriction is illegal. So it doesn't make it somehow trump the law because it wasn't appealed by the developer. That's not how that works. That really only applies to the people who are interested in the permit at that time. And so I guess the point is, you know, if you're going to decide this case tonight, you know, and you have the right to do that, based on the idea that somehow the permit, because it wasn't appealed, is lawful for all purposes in the future, I would ask that we be allowed first, before you make a decision and you know, continue the hearing for maybe a week or 2 weeks, to submit, you know, more papers on that to explain why that's not the case. But, you know, our preference would be that you vote tonight and that you drop the restriction. That would be our preference, because time's ticking. And this loan that they do have is going to run out, and the project is going to stop in a few weeks if, and there's not going to be any more funding if the age restriction isn't lifted. So we're hoping this can be dealt with properly.
Any rebuttal there, boss?
Sure.
Yeah.
Sure. You know, that's a hypothetical. You know, we could throw out a lot of hypotheticals. The situation that we have is that the association, who is basically in the shoes of the original applicant, is the one who's talking about the, you know, the validity or enforceability of the condition. So the hypothetical really doesn't apply here. But we're certain, you know, I'm not arguing that that there aren't lenders out there, as the applicant has asserted, that won't lend because of this condition. And I've also said that I think it would be reasonable, it's obviously the decision of the board and within the board's discretion, but to find that this condition, based on the facts that have been presented during this hearing, makes the project uneconomic. And that would be a valid basis for you granting this modification, in my opinion. But it's obviously within the discretion of the board.
Now, they're gonna build a couple more buildings, are they?
I don't know that there's any plans afoot to build more now.
I don't want to build any, but the board does own the building rights.
Okay.
Right, the development rights passed to the board after 7 years, so I guess it was 2011 or 2012 when the developer's rights ended, and now belongs to the association.
Right. Now, hypothetical. If we did pass this, okay, and I'm not saying we're gonna or we're not gonna or whatever, but everything that we went on the 40B, because I know on the new units, what do we get, $3,000 a unit, and which we contributed all of it to the senior center, which helped build that senior center. This board started it right here, and I want to make sure none of that gets taken out.
No, it wouldn't affect any of that.
I can answer that question too as your counsel. Nothing in the comprehensive permit except this particular condition is at issue.
Okay. That was my question. Thank you. Anybody have any questions? see anybody out there. All right then, I think we can close the meeting. Nobody else got any objections?
If I could
you're
just
done.
briefly, just so you know, the public hearing will start the 40-day deadline period for you to make a decision on this application.
Okay, very good.
If you close the meeting, no new information can be presented to the board.
Right.
Yeah, we need to be able to, there's some other people on the board that aren't here that we should probably talk to.
I'd like to make a motion to continue the meeting.
Yeah, that sounds good. I'll second it.
2 weeks?
For the next meeting?
That's fine. I mean, at this point, if you continue, I do not have to advertise in the newspaper. If you want 2 weeks, I'll check the calendars and if the rooms are available, and I can find this out by tomorrow, then the day will hold.
If I could, Mr. Chairman, on that notice issue, in order to not have to renotice it, you're going to have to announce a date and time certain for the continued date.
Right, so, and that would be in the posting of the meeting.
No, you have to announce it right now.
Yeah.
Yes, you're right. Then, who's got a calendar?
No, I don't.
It's a school.
We're at a school with them.
Yeah, really.
Come on, our lawyer's gotta have one.
Cell phones.
I got a small calendar.
Probably the first of May.
2 weeks would be May 3rd.
May 3rd.
Okay, so,
Here you go.
the motion for continuation for May 3rd.
Sounds good. Is that all right with you, Ron?
Yes, sir.
Good time?
6:30?
Time?
Yep, 6:30, right?
6:30, yeah.
May 30th?
6th.
May 3rd.
May 3rd.
So I'll make a motion, we continue the public meeting to May 3rd, 6:30,
And I'll hold it here at KIVA.
And I'll second that motion.
here in the KIVA.
Wednesday.
All right, have a vote. All in favor?
Aye,
Who seconded it?
I did.
he did.
Aye.
Aye.
Okay, we have a continuation.
Very good.
Thank you. Thank you.
Thank everybody for coming.
Thank you all.
John.